Is OpenAI's ChatGPT and other large language models, which are known as LLMs, infringing on people's copyrights and stakeholders' copyrights? Hi, my name is Derek Fahey. I'm a registered patent attorney and a trademark attorney with the Plus IP firm. And this is going to be a brief video on whether or not ChatGPT is going to be considered infringing on others' copyrights or whether it's considered fair use. So first off, OpenAI has actually discussed this. They actually submitted a response to requests for comments by the United States Patent and Trademark Office about whether or not their use is considered fair use or whether or not they are committing copyright infringement. And you can take a look at that. It's online. If you read the comments below, you can find that as well. But I wanted to talk about one of the cases that I believe are actually going to be helpful to help the courts decide this issue. It's a Ninth Circuit case, but before we get to that, Ninth Circuit Court of Appeals case, but before we get to that, I just want to briefly talk about how ChatGPT and other large language models, or LLMs, work. Essentially what they do, or specifically ChatGPT, is it doesn't actually, according to them, they don't actually copy the source code. They actually read all this information and then they analyze it and they train their models based upon the patterns that the large language models detect. And using those patterns, they're able to help you generate content. Today, I'm going to kind of focus on whether the training of the model is considered a copyright infringement. So, in my opinion, I believe that an easy way for the Supreme Court to rule will be to side with the cases that are coming out of the Ninth Circuit Court of Appeals. Specifically, which we're going to talk about today, is the Sega case. I actually have a little paper here. This is the name of the case. It's Sega Enterprises versus Accolade, and it's 977F Federal Circuit 1510, 9th Circuit, 1992. It's an older case, but this is actually really instructive. So that case, it was based upon the Sega Genesis console, and Accolade actually copied the computer code in order to create its own actual computer video game. And what it did is the court actually, in the Sega case, actually found that the copying was fair use under a principle called intermediate copying. And that intermediate copying is the same theory that OpenAI is actually presenting and has presented to the United States Patent and Trademark Office in its comments. And I think it provides some really good reasoning as to why, if these cases eventually go to the Supreme Court, whether or not it would be considered fair use. Now, fair use for copyright infringement really has four factors. It has the purpose of the use, that's factor one. The nature of the use, that's factor two. The amount of the use, and the last factor is the effect on the market. So in the Sega case, essentially what happened in that particular case was, the Accolade, the defendant in that case, they actually copied the source code from this video game, and they reversed it. They had to copy it to actually extract the code to learn how the code operates, the functional features of the code. In that case, the court found that the purpose of the code, the use of the code, which was, the copying in order to get the functional features out of the code, the purpose and the nature of the use of the copying actually weighed in favor of Accolade. It said, when you look at the fact that they copied the code, the fact that they had to do the copying to extract the functional features of it, that was considered a factor that weighed in favor of finding a fair use and in favor of not infringing. That is very similar to, I think, what that could be argued for ChatGPT. They're not, in fact, it's even more in favor. They're not actually copying the code. They're not actually copying the content. They're actually reading the information, and then based upon all the information, they're actually creating patterns that they use to generate material in the future. So I think if you're going to analyze it under the same case, if you're going to analyze the fair use and side with this reasoning, you can say that the use actually weighs in favor of fair use based upon in favor of fair use in favor of OpenAI. Interestingly, the court in Sega also said that how you have to look at the benefit, but I'll talk about that in a second. The court actually moved in the Sega case to the fourth factor, which is the effect on the economy, or the effect of the use. And it's basically said, yes, we know that that Accolade copied, but the effect that it has on the market is allowing other competitors to actually compete with these functional features that are not protected by copyright protection. So this actual favor weighs in favor of fair use and in favor of not infringing. I thought that was really interesting. Similarly, OpenAI can argue the same thing, that when you look at the effect on the market, we're actually just pulling out the principles and creating new content that is actually not going to affect the original content that we have learned these parallel patterns from. What I also thought was interesting was that in weighing these factors, the second factor talks about the nature of the use. For the nature of the use, the court in Sega actually said that because the nature of the use was that you had to actually copy, the only way you can get this information out was by copying it in order to get the functional features of it. That nature of the use was also weighing in favor of fair use. I think the same argument can be made for OpenAI. And they're saying that, listen, in order to extract this information from, in order to extract these patterns from all this information, we have to actually retrain all this information. And because we're not actually copying the information, we're just learning the patterns of how copyrights are written or how the information is written, that this should weigh also in favor of fair use. On the first factor, what I thought was really interesting and I thought will play a big role in the OpenAI and other LLMs is the fact they talked about that you have to look at the benefit. The fact that how this new technology being created. So in Sega, the court actually in the first factor said you have to weigh the benefit to society more or less by allowing this copying to be. And I think that is something that a court in the future, Supreme Court, I believe so, or maybe even the legislator may pull on, is the fact that hey, this large language model technology is so beneficial. This intermittent copying should be allowed because it's such a benefit to society and such an innovative technology. In fact, in another Supreme Court case, the Supreme Court actually cited the Sega case, which talks about this particular component, and this actually goes to the first factor. So I thought that was really interesting. I think my hot take, I could be wrong, but I think that how the Supreme Court, if they decide on it, will actually look to the Ninth Circuit Court of Appeals case, the Sega case. We'll pull it up again. All right, Sega Enterprises versus Accolade. It's 977 Federal 2nd, 1510, Ninth Circuit, 1992. It's an older case, but it has a lot of principles I think would be really useful for OpenAI to argue, and I think that based upon the previous rulings, I think, and quite honestly, the benefit to society that ChatGPT and other LLMs are providing, I think it's just an easy way to actually say it's fair use and they're not infringing. Hope you enjoyed the video. If you have any questions, give me a call. You can find my information on our website, www.plusfirm.com. I'm on Instagram, Derek Fahey, PA. Have a great evening. Enjoy. And looking forward to hearing from you soon. Please like and subscribe to my video.